Well, at 10:11 a.m. today, Donald Trump's lead criminal defense lawyer, Todd Blanche, stood and said, "Your Honor, the defense rests." The truth was, there was no defense. The team of high-priced Trump defense lawyers are actually paid by the deluded people who send in contributions in response to Donald Trump's relentless begging for money from people he promised he would never ask for money. When Donald Trump began his first presidential campaign, his major selling point to voters was he was so rich that he could pay for his own campaign and therefore was incorruptible, and he would never ask them or anyone else for money. Then Donald Trump proceeded to never spend a penny of his own money on his presidential campaign. He loaned his first presidential campaign some money at the beginning, but of course that campaign paid him back through the donations of those poor, deluded people who send money to the liar who promised he would never ask for money. And now their money has gone to a high-priced legal team who could not come up with any defense at all in Donald Trump's first criminal trial. They came up with conflicting defense theories that they offered in cross-examination questions of some of the witnesses who testified for the prosecution. But an actual defense in a criminal case is not measured by questions defense lawyers ask in cross-examination. Those questions are not evidence. Next week, when Judge Juan Merchan is instructing the jury, he will tell them that lawyers' questions are not evidence. Witnesses' answers are evidence. And so the Trump defense presented no evidence, none, in defense of Donald Trump against the crimes he is charged with. None, no defense. The first witness they called was a technical witness who did not add any evidence or information to the case whatsoever. He was a young paralegal assistant who works for the Trump defense team who had created a spreadsheet of a list of phone calls. That was it. His testimony took only a few minutes, and the document that he created was accepted as an exhibit in the case, and that was that. And then yesterday, the Trump lawyers, possibly at the insistence of Donald Trump, made what every fair-minded observer of the trial has called the grotesque mistake of calling criminal lawyer Robert Costello, whose chief currency as a criminal lawyer, judging by his emails exposed in this trial, is that he is a close friend of the deranged Rudy Giuliani. Rudy Giuliani was Robert Costello's boss in the 1980s when Giuliani was the Manhattan U.S. attorney and Costello was a federal prosecutor working for Giuliani. Robert Costello's turn under oath yesterday was the witness stand equivalent of drunk driving. At this hour last night, I read you the full transcript of what Judge Juan Merchan did when Robert Costello decided to vocally disagree with the judge's ruling on objections while he was sitting there on the witness stand. The transcript entry that we in the courtroom all heard shows Robert Costello saying, "Jeez." Jeez was the chosen spelling by the court reporter. That's what we heard. I could hear it in the last row of the courtroom yesterday. And none of us in the courtroom had ever seen anything like that or heard anything like that, especially from a witness who is a lawyer and should know better, much better. Judge Merchan was shocked. He leaned forward. He asked Costello to repeat himself, to which Costello said, "Strike it," which is lawyer talk for never mind what I just said. Then, as we found out later, the judge saw Costello continue to signify his irritation with and disrespect for the judge in ways that we couldn't quite see from the audience. And the judge ordered the courtroom cleared so that he could talk about it directly to Costello. "Clear the courtroom," were the words no one in that courtroom had ever heard before the judge said that, including the court officers. They had never had to do that before. With everyone out of the courtroom, we learned later in the transcript that was kept of what happened when we were all out of the courtroom, Judge Merchan said to Costello, Sir, your conduct is contemptuous right now. I'm putting you on notice that your conduct is contemptuous. If you try to stare me down one more time, I will remove you from the stand. I will strike his entire testimony. Do you understand me? Mr. Bove, yes, Judge, I understand. When Donald Trump's criminal defense lawyer said, yes, Judge, I understand, he and the rest of the legal team also fully understood what a catastrophic mistake it was to put an uncouth buffoon on the witness stand as a defense witness for an uncouth buffoon. At 9:29 a.m. today, Robert Costello, the red-faced, white-haired, 76-year-old criminal lawyer, entered the courtroom again to resume cross-examination by Assistant District Attorney Susan Hoffinger, who the day before Costello had specifically insulted by telling her to speak into the microphone, ordering her to speak into the microphone when she already was speaking into the microphone and everyone in the courtroom could hear her. And that was a moment that no doubt helped expose more of the ugly essence of Robert Costello to the jury of 7 men and 5 women. When the jury entered the courtroom 3 minutes after the witness this morning, the community of the courtroom that the jury has come to know so well had changed dramatically. The presence of armed court officers who have been the most courteous and helpful guides to all of us taking our places in that courtroom every day had more than doubled. Where there used to be 1 court officer standing in the center aisle, there were 3. At the back of the room, where there used to be 2, there were 4. There were more higher-ranking officers in the room than we had ever seen at one time. One of the court's administrative officials, who has been especially helpful to members of the news media, but who is rarely in the courtroom, was now standing in the back of the courtroom observing everything in that room. This dramatic demonstration of extra control of the courtroom by the court officers was completely lost on the defense lawyers and the defendant and the prosecutors because they had their backs to that part of the room. They had their backs to the court officers. They were just facing front where they could just see the judge and the witness and some of the jury. But the jury could see everything in that room. The jury could look out there and see at least double the amount of those friendly court officers who they've come to know. More than double of those court officers than they had ever seen in that courtroom before. And the jury could not know why. They had been sent out of the room by the judge yesterday, the first time the judge decided to, as he put it, speak directly to Robert Costello about what the judge called the decorum in the courtroom. It was only when Costello continued his disrespectful courtroom conduct that the judge cleared the courtroom of all of the rest of us, of the reporters, everyone else in the room. And the judge had a more private one-on-one with Costello while, of course, the lawyers were all still present. The jury could not know that this huge new show of force and control in that courtroom this morning was all because of the contemptuous conduct of the only witness Donald Trump's team brought into that courtroom to offer actual testimony in this case. And his testimony had absolutely nothing to do with the crimes Donald Trump is charged with. Robert Costello was one of the lawyers who the prosecution's star witness, Michael Cohen, consulted after the FBI executed search warrants at his home, the hotel room where he was temporarily living, and his office. When Michael Cohen became a cooperating witness in that FBI investigation, it eventually led to Michael Cohen pleading guilty to crimes, including crimes involving the payoff to Stormy Daniels that Michael Cohen said was done at the direction of Donald Trump. Under cross-examination today, it became clear that Robert Costello was eager to become Michael Cohen's lawyer, so eager that he wrote an email to his son boasting about how he was on the verge of becoming the defense lawyer for, quote, the personal attorney to President Donald J. Trump. He told his son, quote, I will be on the team. The trouble is, his emails reveal that the team was bigger than Michael Cohen. In cross-examination, it became very clear that Michael Cohen was not Robert Costello's primary interest. It is customary for lawyers to ask witnesses to read their own emails aloud as evidence. Assistant District Attorney Susan Hoffinger tried that yesterday on cross-examination, but Costello couldn't do it. He couldn't read his own emails without constantly inserting new editorial comment on his own emails. And so today, Susan Hoffinger read the emails herself. Can you please blow up the last 11 paragraph, please, in yellow? And then she read Robert Costello's email to his law partner. Quote, our issue is to get Cohen on the right page without giving him the appearance that we are following instructions from Giuliani or the president. In my opinion, this is the clear, correct strategy. That's not a strategy to help Michael Cohen. Yesterday, when the district attorney asked Robert Costello to interpret one of his emails, Costello's answer was that the email, quote, speaks for itself. And so today, after reading that email that I just read to you, District Attorney Hoffinger said, question, and as you said yesterday, the email speaks for itself, correct? Answer, sometimes. And it got worse for Robert Costello. District Attorney Hoffinger quoted another email to his partner about Michael Cohen, quote, and this is a quote from the email. What should I say to this a-hole? He is playing with the most powerful man on the planet. Now, that email certainly speaks for itself, does it not, Mr. Costello? Answer, yes, it does. It was very clear that Robert Costello's interest in trying to become Michael Cohen's lawyer was to be on the team, not of Michael Cohen, but the team of the man who Costello thinks of as the most powerful man on the planet, the man who was sitting across the room from Robert Costello in the defendant's chair. Robert Costello left the witness stand in disgrace at 10:11 a.m. this morning after 42 minutes on the witness stand this morning, establishing absolutely nothing for Donald Trump's defense against the criminal charges of falsifying New York business records in order to illegally help his 2016 presidential campaign. The judge then explained the scheduling dilemma that he faced. He told the jury that he likes to keep the final arguments by the defense and prosecution together so that they aren't separated by a day or a weekend, and that he would need additional time to prepare his legal instructions for the jury. So he pointed out that because they were already scheduled not to meet Wednesday of this week, that the earliest they could begin the lawyers' summations without having to break them up would actually be sometime maybe Thursday of this week, and that might not allow everything to be completed before the Memorial Day weekend, or it would send the jury off into deliberations at the end of the day on Friday. And so the best way for the judge to handle it, he decided, was to send the jury off today into what will become its Memorial Day long weekend. And that happened right after the last witness today, Robert Costello, left the witness stand. The judge spent the afternoon considering arguments from both sides about what should be included in the judge's instructions to the jury that will probably be delivered next Wednesday, the day after the lawyers make their final arguments to the jury on Tuesday, which of course will be the day after the holiday, Memorial Day. And so here we are. The case is in. There will be no more evidence. The prosecution has presented evidence to support every element of the crimes Donald Trump faces in that courtroom. The jury of 12 Manhattan residents will begin deliberating next week on the question of whether the evidence presented by the district attorney amounts to proof beyond a reasonable doubt that Donald Trump committed those crimes. There is nothing about the jurors themselves that give you the slightest hint of how they might be leaning in the case or what evidence they think is important. But they are always very attentive to everything in that room, especially Judge Merchan's instructions. And they will surely be very attentive when the judge delivers the last words they will hear before they begin deliberating in this case. Judge Merchan has said that he hopes to keep his instructions to about an hour or less. And this afternoon, in a hearing without the jury present, lawyers on both sides argued about what those instructions should be. It did not go well for the Trump criminal defense lawyers. Emil Bove brought up something that the judge had ruled out of the case a very long time ago, long before the trial began, and this was frustrating for the judge. Judge Merchan said, look, Mr. Bove, this is an issue that has been going on for a very, very long time. I wrote a decision on this. My decision is dated February 7th. In that decision, I directed the defense to provide notice of disclosure of your intent to rely on the defense of advice of counsel by March 11th, 2024, and to produce all discoverable statements and communications within his possession or control by the same date. What that means is that the judge told the Trump defense team, if you're going to use the "my lawyer made me do it" defense, you have to tell us before the trial, because there are many evidentiary requirements for making that defense. That defense would essentially be, I just followed the advice of my lawyer, Michael Cohen. There are technical requirements for making that legal defense, which Donald Trump's lawyers chose not to do. And so, in his mounting frustration this afternoon, the judge said, later on, the defense, on advice of counsel, morphed into something called the presence of counsel, which I had never heard of and I was not familiar with, but I addressed it in the motions in limine. And at that time, I indicated that you are precluded from arguing this legal claim of presence of counsel. There was no such thing. It's just a way to get around having to turn over documents related to the advice of counsel. Now, this term, presence of counsel, has morphed yet again into something called involvement of counsel. My answer hasn't changed, and honestly, I find it disingenuous for you to make the argument at this point. And Mr. Bove attempts to get up at that point. The judge says, please don't get up. I let you speak, right? I let you speak. Let me speak. Mr. Bove, all right. Judge Merchan. It was concerning when the term was changed to presence of counsel. I couldn't believe when I saw it again in your submission now, calling it involvement of counsel. And I understand the argument that you are making. I'm telling you, my ruling is the jury will not hear that instruction from the bench, nor are you permitted to make that argument, period. The Trump lawyers cannot stop testing Judge Merchan's patience, but in the process, they can't stop humiliating themselves professionally in their representation of the uncouth buffoon they sit beside all day at that defense table.